You suffered significant harm and injury as a result of a doctor's carelessness, and now you want to go ahead and bring a lawsuit against that particular doctor. We go ahead and validate that you have a case. We hire the best medical experts we can find to review your records, who then determines that yes, you do in fact have a valid case. Now, as we start the lawsuit, I tell you that we are required to share your medical records with the defense. You turn around and say, absolutely not. You want to know what this is all about? And why you're going to have to release those records? Come join me for a walk near the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. When you bring a lawsuit seeking money as a form of compensation for harms and losses that you suffered because of someone else's carelessness, your medical condition becomes an open book, which means that if you are truly claiming that you suffered significant injury because someone did something carelessly, now what you are doing is you are saying, hey, look at me, I suffered permanent harmful injury, I am now disabled, I am now incapable of doing those activities I used to do before. Now, when you go ahead and bring a lawsuit, the defense says, hey, tell us what it is that you're claiming. Tell us what problems you are experiencing, what injuries you have, what limitations you have. Now, from their standpoint, how do they truly know what you are claiming is true? How do they truly understand whether what you are saying is accurate? The only real way for them to justify that your injuries are limiting, they are disabling, they are disruptive to your family, to your life, is to get copies of your medical records. So you should know that in a civil lawsuit in New York, not only are we required as the attorney who represents the injured party to go ahead and give copies of the records that we have obtained to review your case, to give them to the defense, but we are also obligated to go ahead and give them permission slips. Lawyers call that authorizations, that will allow the defense to go ahead and get copies of your records directly from the various doctors you have treated with, as well as the various hospitals you have obtained treatment from. This way, they can not only go through the records that we have provided, but they can also confirm and verify and validate that the records that they obtained personally and directly from your treating doctors are the same and they are accurate and correct. Only by doing that will they have a true ability to review your case to determine whether or not your injuries truly have merit. Now, that doesn't mean to say that they will agree with the value of those injuries, nor does it mean to say that they will agree with what we are claiming occurred, meaning that the doctor violated the standard of care, causing you harm and injury. They are always going to dispute that. In fact, they will have their own medical experts look at the same exact records that we have obtained. We're all dealing with one set of records here, right? The records that you have concerning your medical care and treatment. We have our medical experts review those records who confirm that you do in fact have a valid case, that number one, the doctor or doctors were careless. Number two, that carelessness was a cause of your injury. And number three, that your injuries are significant and or permanent. All three of those things have to be confirmed in order to go forward with a case. Now, looking at those same exact medical records, the same ones that our experts reviewed, the defense experts are now going to look and review those same exact records. And isn't it remarkable that they will reach the total opposite conclusion that number one, their doctors did absolutely nothing wrong, that they complied with the standard of care. And then they will say, you know what? Even if we didn't, whatever we did not cause or contribute to your injuries, Mr. Patient. Then they will say, hey, you know what? If we did something wrong, so did you, Mr. Patient. They're pointing the finger back at you, the injured patient. And then they'll say, you know what? If we did something wrong, and you did too, Mr. Patient, and we did cause you harm and injury, guess what? Your injuries really are not as bad as you claim them to be. So they will do everything possible to minimize the extent and the value of your injuries to try and show not only that they did nothing wrong, or that they didn't cause any harm because they did something wrong, or that your injuries really aren't as what you claim them to be. So that is fascinating because you have two different medical experts on different sides looking at the same exact records, reaching totally opposite and different conclusions. But getting back to the question I raised at the beginning of this video, why are you required to release copies of your medical records? It's because you, the injured patient, are the one claiming that you suffered physical harm and injury. If you had no claim for physical harm and injury, there would be no need to release your records, and there would be no need for you to go forward with a potential case. But these civil lawsuits are designed to accomplish one thing: to obtain money as compensation for all of your injuries. And once you do claim that you suffered physical harm and injury, now the defense says, prove it, show it to us, validate, let us have the record so that we can see for ourselves that what you are claiming about your injuries are in fact true. And if you do not, if you refuse to turn over those records, if you refuse to provide permission slips, those authorizations, so the defense can go ahead and see copies of your records, guess what? Now you, the injured patient, are the one who's going to be penalized. If we don't provide those particular items that we are obligated to do, the defense will reach out to the court and say, Judge, Oginski and his client are failing to provide copies of the medical records so that we can validate these injuries here. Without that, we are going to be severely prejudiced. And you know what? They are absolutely correct. And the judge would be well within his right to agree with the defense and now to begin to punish us because of your failure to agree to turn over those documents. So do you have to do it? In New York, the answer is absolutely, regardless of how you feel about disclosing your personal matters, your medical condition to some stranger. That's what happens when you bring a lawsuit seeking compensation, seeking money for all the harms and losses and damages you incurred. You know, I realize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you are thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.